This is Unchained Frequency. I'm your host, Malik Liberty. Listen closely, because today we are exposing the conversion game. But before we get into exposing the conversion game, I had a letter, or not necessarily a letter. Yeah, it is a letter. It's an actual letter, but it was in my cloud that I forgot about so long ago. And this is very, very powerful of what we're talking about, the right to travel. Okay. Now, this letter is from the United States of America Department of Travel, which is now Department of State. Okay. And this letter was addressed to the governor of Raleigh, North Carolina at the time. And it was dated November the 23rd of 2015. And this was to Governor Pat McCrory, right? And it says, read. It says violations of U.S. Supreme Court rulings regarding the right to travel. And then it had in the subject, education of law enforcement and North Carolina judiciary. We're going to get into that at the end of this episode, okay? It's very, very important that we discuss that. I'm going to read it for word so you can understand why the right to travel is a right and not a privilege. Okay, so let's get back into the episode of discussion. So, okay, the state did not invent your liberty. It did not grant your right to move, to raise your children, to worship, to work. But over time, the state has been busy relabeling those rights as privileges, then creating licenses, registrations, and fees to control them. Today, we stay focused. The right to travel, the legal line between public and private, and how the law protects you when the state tries to convert liberty into license. No conspiracies, no myths, no just law, court rulings, and how to use them. If you want to defend your freedom, you need the facts, the cases, and the strategy. This is episode 6, License versus Liberty, the conversion game. Let's go. What we are defending is right to travel. The right to travel within the United States of America is a fundamental constitutional liberty. The Supreme Court has repeatedly recognized that your freedom to move from state to state, to enter, to leave, to be treated equally as a newcomer is part of the liberty protected by the Constitution. See Crandall versus Nevada, 1867, and modern summaries of interstate travel doctrines. Bottom line, moving across borders inside the Union does not strip you of constitutional protections. The Constitution travels with you. Read Kent versus Dulles, Shapiro, Saenz for the modern doctrinal line. Key legal snapshots. Okay? I really don't like using legal too much. Legal and illegal. I always like to stick to lawful and unlawful. So, the key is this, two things. Crandall versus Nevada said, states may not tax or block people leaving the state. 2, the Supreme Court recognizes the right to travel as a core liberty, even if driving as a particular mode of travel can be regulated. The distinction between a right to travel and regulation of a mode of travel is central. So we're going to get into the definitions, right? Right versus privileges. We must be clear. A right exists without government permission. It is not invented by statutes. A privilege is conditional permission the state grants and can revoke. Always remember that. Anytime you get a license for anything, I don't care if it's a CCW license, meaning concealed weapons permit. I don't care if it's this license, that license, driver's license. All those can be revoked. And the fact to that is, look at what's happening with the SNAP benefits. The SNAP benefits, most people don't understand, that's a privilege. That's not a right. Those are benefits and privileges. Most people don't understand that because they don't read. Now, here's two constitutional amendments that you need to pay very, very close attention to. It is the Ninth Amendment and the 10th Amendment, okay? The Ninth Amendment states the enumerations in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, okay? So what does that mean? The Ninth Amendment means that just because some rights are written in the Constitution doesn't mean those are the only rights people have. It protects all unlimited rights that belong to the people, such as privacy, travel, and personal freedom. In short, people have more rights than just the ones mentioned in the Constitution. And that's very important that you have to remember with the Ninth Amendment, because we do. It's just that most Americans don't read. They don't study. Now, the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The 10th Amendment limits the power of the federal government. If the Constitution does not specifically give a power to the federal government and doesn't forbid the states from having it, then that power belongs to the states or the people. This reinforces federalism, the shared power between national and state governments. For example, education, law enforcement, and many public safety matters are controlled by the state, okay? You probably can find that in the Bill of Rights as well. U.S. Constitution ratified December the 15th of 1791. I cannot highly stress it enough, people. You have to read, okay? Read. So the simple rule you can tell is this. If the activity is private and involves only private parties, constitutionally protected liberties usually apply to prevent state interference only when there is a state action or the state compels or enforces the private restriction. If the state is directly involved, constitutional limits apply. Public versus private. They don't mix, okay? Public and private do not mix, and people do it all the time. They don't understand the private side. They don't understand the public side. There's a difference between the two, all right? The only time you should be in the public is if you're in commerce, all right? When you're in the private, you're in the private. That means it has to be private. And this is something that sometimes I can't understand why so many people take so much private information and just splurge it all out everywhere. Certain information or certain personal things should not be displayed or showed, period. That's private, period. Now we get to the legal wall. The state action doctrine. The Constitution limits state action, not every private act. But the line is not flimsy. The court has given us doctrine and bright cases to decide when private conduct becomes state conduct. Learn those lines. They are your shield. Key Supreme Court rulings. State action doctrines. 1. Shelley versus Kraemer, 1948. Private, racially restricted covenants exist as private agreements. But when courts enforce them, the enforcement becomes state action. Courts cannot enforce private covenants that would violate equal protection. The lesson? Private agreements are private. State enforcement converts them into state action. 2. Burton versus Wilmington, Parking Authority, 1961. Where the government and private businesses are so intertwined that private discrimination is fairly attributable to the state. The discrimination can be condemned as state action. This is the close nexus or joint action principle. 3. Jackson versus Metropolitan Edison Company, 1974, and Lugar versus Edmondson Oil Company, 1982, and Blum versus Yaretsky, 1982, refined limits. Heavily regulated, private actors or private acts aided by the state are not automatically state actions. The court looks for a sufficiently close relationship between the state and the private conduct. Contracts, enforcement, coercions before constitutional restraints apply. What that means for parents and travelers, if a private daycare, private school, private neighbor, or private company takes actions with no state enforcement, the Constitution may not apply directly. But if the state authorizes, enforces, funds, or compels the private action, that is a constitutional problem you can challenge. For example, if social services agencies compel private actors to remove children, or if courts enforce a private action that violates rights, state action may be present. How states converts rights into license and privileges. Now, this is very, very important. You have to pay attention because this is still relevant until this day. The conversion game is subtle and legalistic. The state doesn't say, quote, "we are taking your rights." It relabels operations of a motor vehicle instead of movement, marriage licenses instead of family formation, occupational licenses instead of the right to earn a living. Once rebranded as a regulatory matter, the state wraps it in statutes, codes, permits, and penalties. Then it enforces compliance with police power, rhetoric, public safety, welfare, order. But the Constitution still constrains that power. When the regulation actually burdens a fundamental right, like interstate travel, courts apply heightened review and protect liberty. See Bell versus Burson, 1971, and Murdock versus Pennsylvania, 1943, for important limits about licenses and burdens on liberty. Important legal anchors here, right? Bell versus Burton, Bell versus Burson held that suspending a driver's license is a deprivation of property interest requiring due process. Court protections apply when license become essential to a practical exercise of liberty. That's interesting. That goes back to what? Due process is what? It's the Fifth Amendment, okay? And deprivation of property and interest, that's all in the Fifth Amendment there, okay? Commerce exceptions, what the state can legitimately regulate. When the activity is clearly commercial for hire, carriage, transporting, passenger for pay, commercial trucking, states have broad authority to license and regulate under their police powers and the Commerce Clause framework. But when a private citizen is merely exercising constitutional right, traveling from one place to another for private reasons, licensing aimed solely to burden that movement faces constitutional scrutiny. See context at the law-annotated summaries for the interstate travel. Now we're going to get into the historical context and the antidote. You want historical depth, right? Here it is. The idea that rulers regulate movement and privilege is old. Okay. Feudal lord controlled peasants' movement. Permission was required to leave a fief. Magna Carta pushed back against arbitrary royal authority by affirming liberties in the face of sovereign overreach. Centuries later, Jim Crow laws used licenses and bureaucratic procedures to limit Black mobility in civil life. And reminded that licenses can be a tool of oppression if unchecked. Okay, the antidote one, feudal's rights. Under feudal law, a serf was legally bound to his lord's land. To leave without permission could bring punishment. Contrast that with modern citizenship, where the national union rests on the idea that citizens can move within a single national polity. That contrast is the seed of modern travel liberty doctrine. Antidote, Magna Carta. The 1215 Magna Carta established limits on the king's power and conceptually influenced later documents that protect subjects from arbitrary restraints. The same principle that undergirds modern due process. Antidote 3, Jim Crow and bureaucracy. In 20th century America, various administrative rules and permits were used to control access to voting, travel, jobs, and housing. In short, to convert freedom into conditional compliance, the courts have repeatedly pushed back when those administrative burdens became discriminatory or punitive. Popular misconception to debunk. They say this loud: you need a driver's license for all travel. Interesting, right? False. A driver's license is a statutory regulation for operating a motor vehicle on public roadways, typically justified by safety and commerce concerns. The constitutional right to travel does not evaporate because a state issues a licensing regime for a mode of travel. The legal fight is to prevent licenses from becoming a cloak for stripping the underlying liberty itself. See Crandall, Shapiro, and Saenz. And Black's Law Dictionary has already defined what a driver is, and Bouvier's too. I think I've mentioned that before, if I can recall, in earlier episodes. You probably go back and listen to the first few. It's there. So practical mini guide, right? How to defend your rights. Okay, now this is something that I've kind of critiqued a little bit, and this is something that I would do. That doesn't necessarily mean that I'm giving you legal advice. I'm not an attorney. I'm not a lawyer. I'm not any of those corporate or corporatized corporations that are for profit, okay? I cannot give you legal and lawful advice, and nor would I give you legal and lawful advice. This is what I would do, per se, all right? Besides, I wouldn't want to be have anything to do with anything with the Bar Association anyway, okay? That's just my take on it, and we're going to do some episodes in the future about the bar and how to really represent yourself lawfully without an attorney. So let's get back into the mini guide, okay? Okay, this is the part you can use in court or in real life, okay? Don't wing it. Document, preserve, and litigate carefully. So step 1, collect the record, preserve facts, time, date, place, officer, agents' names, batch numbers, actions taken, exact words spoken. Take photos, record if legal in your jurisdiction. Keep all paperwork and recipients. Okay, now, like I say, legal I don't like to use, but lawful I like to use, and it is Constitution. That's when I think that's your First Amendment right. You have a right to record. You have a right to free speech, and et cetera, et cetera. Okay, they can't tell you can't record, and if they do, they're in violation of the Constitution, period. Doesn't matter what they think or what they say. Step 2, identify the legal theory. Is this a state action? Interesting question. Did a government official force the outcome, or did a private actor act with government enforcement? Another interesting question. Refer to Shelley, Burton, Lugar test. Does the action burden a fundamental right? Interstate travel. We just spoke about interstate travel. If yes, the court may apply strict scrutiny or other heightened review. Look to Shapiro and Saenz. Step 3, administrative challenging first. Basically challenging jurisdiction. if required. If the state requires exhaustion of administrative remedies, appealing a license suspension, internal DHS review, follow the required administrative paths, but preserve all constitutional claims for court review if necessary. What I like to call administrative path is the administrative process. Paperwork, guys. If you're going to get into this type of battle, you got to be ready to do some paperwork. This is not easy, and this is not the faint of heart. This is not for the weak. Step 4, file strategically. Okay, for urgent deprivations, child removal, license revocation, consider emergency relief, TRO. I call it temporary restraining order or preliminary injunction on constitutional grounds. Ask the court to preserve status quo pending full hearing. For declaratory relief, ask the courts to declare the state statutes unconstitutional as applied to you. Step number 5, use the right precedent. I cannot highly stress that enough. You got to know what you're doing when you go and stepping into this type of limelight or type of arena with these people. You got to know exactly what you're doing, people. Like literally, because they will eat you up for breakfast and spit you out. Okay, so when a fundamental right is burdened by state action, you want to cite Shapiro versus Thompson, Saenz versus Roe, Crandall versus Nevada, Kent versus Dulles, and relevant state action doctrine cases Shelley, Burton, Lugar, use Bell versus Burson, where license deprivation implicates due process. Step number 6, build the narrative. Court responds to clear pleadings. Show how the regulation is not tailored to a compelling state interest or how the state has overreached into private, non-commercial movement. Document alternatives the state could use to achieve safety without burdening rights. Step 7, seek counsel and amicus. Get an attorney experience in civil rights and constitutional law. If the issue has broad public interest, invite civil liberties groups to monitor or file amicus briefs. Okay. Now, like I say, for me, I like to handle my own affairs. Sui juris, okay, all right, or proporia, not pro se, but pro proporia or pro personam. You know, I like to do my own thing, my own paperwork, and try not to deal with attorneys because you got to understand the game is totally rigged. Attorneys is not your friend, okay? Especially the ones that's supposed to be public defenders. I call them public pretenders. I have some experience with them. I had a situation with a cousin of mine. He had to fight a case for a whole year, and I helped him with that case. And I'm going to tell you something. These public defenders, they are not for you. So you better be careful when you get a public defender. Now, if you get a public defender, here's what you should do. And this is just mine, this opinion. I'm not giving you legal or lawful advice. I'm just stating the obvious facts. You need to put them in the private. That means you got to give him or her some instructions of what you want them to do. Okay? Because if you don't, you're going to be in some serious trouble. They could turn the whole situation around and now they control the narrative. And now you stuck back at square one. You don't want that. Okay? So you want to have templates and procedural tools. Okay? Use motions for injunctive relief. Motion to dismiss counterclaims that lack state action foundations, and Section 1983 claims when a public official acts under color of law to deprive rights if the action meets Section 1983 standards. You can also get them too as well, not just with Section 1983, but also Section Title 18, your Title 18241 and Title 18242. You need to read that up or pull that up. And you can actually go to maybe law.Cornell.edu, and you can find that there of what those two codes mean. Okay, that's even actually under color of law too as well. I think if I don't recall, I'm assuming here, but it's been a while since I've been in that code. But I think I can remember. I'm just going to paraphrase, not quote, not quote here. Let's see. 241. It's got to be conspiracy under color of law, and 242 is deprivation of rights under color of law. But don't quote me on that. You can go pull this up for yourself. I'm just here to give you as much information as I can to help you to get the remedy, because there's remedy out there. You just got to know what you're doing. You got to go out there and know how to get it. Okay, section 7. Okay, recent cases and news, right? So here's what you need to read now from 2024 to 2025. Okay, all right. And here is the current examples, okay, that I've come across, okay. Courts are still applying the travel doctrines in contexts like abortion access and interstate assistance. In 2025, a federal judge in Alabama ruled that the state cannot persecute groups helping residents travel out of state for abortions, citing constitutional travel protection and free speech concerns. That decision is an example of courts enforcing travel rights in modern controversies. Read Reuters and the Washington Post coverage for the ruling and context. Okay, where to watch for the updates? Here's what you need to go. You need to go to SCOTUS blog, daily coverage, and relist, and go to Supreme Court official docket, supremecourt.gov, for petitions and the Shapiro, all right, Law.Cornell, Legal Information Institute, right? I've always liked to go into law.cornell.edu. That's one of my favorites, and also Justia.com. Okay, and this is where you want to go for the annotated constitutional topics like right to travel, state actions. That's where you want to go. Okay, so here's an important point, though. As of right now, November the 2nd, 2025, the court travel doctrine remains intact. No Supreme Court ruling has eviscerated Shapiro and Saenz and Crandall foundations, but litigation continues at lower levels with states test boundaries, especially on interstate abortion travel, enforcement across state lines, and administrative licensing requirements. Okay, so keep checking the dockets. And you can see the Alabama examples there, or what happened, all right, in those dockets. You just got to do your research. You just got to look. If I can look, you can look. And let me tell you something, this is not easy to do. I'm spending a lot of time, a lot of hours, and but it's well worth it, because as I do all the research, I'm learning more and more about my rights too as well. This is why I literally came to this what's the name? This platform to help you guys. I'm doing all of the work here. All right. So we're going to go to common counter arguments and how to answer them. Okay. Because they're going to try to use what I call obfuscation. They like to obfuscate, especially the judges. When you ask them certain questions, that's what they do. They probably get a little annoyed with you, but always stay in honor at all times, no matter what. Let them stay in dishonor. And here's also what you probably need to do is, if I were you, if I was in a situation, I'm having a situation with a court citation, I would bring my own court reporter. Don't trust nothing they do, period. You cannot trust these people. They're for profit. They're corporations masquerading as a government, period. All right, so we're going to go to the common counter arguments and how to answer them. Okay, you will hear reasonable and unreasonable pushback, right? I just stated that. So here's how to reply with law and force, but stay in honor. Okay, so counter. Driving is a privilege. You must have a license. Okay, here's what I would say. Operating a motor vehicle on the public roads is regulated, but the regulation cannot be used to extinguish the underlying constitutional right of movement. Courts protect travel. Licensing is a regulatory overlay that must be justified. Cite Bell versus Burson on due process and Shapiro and Saenz on travel. Okay? So here's another counter, right? States need licenses for public safety. Okay, here's what I would say. Here's my reply. Public safety is a legitimate state interest, but safety cannot justify discriminatory or durational residency rules that penalize movement. The state must tailor rules. It cannot simply condition rights on arbitrary permissions. Cite strict scrutiny precedents where applicable. Shapiro and Saenz. Here's another counter. This is private regulations. The Constitution doesn't reach it. Okay? And the reply, as always, should always be educational and be calm when you're replying to them and answer their question and counter everything, right? Okay, so here's what I would say. If the state enforces, authorizes funds, or compels the private section, it becomes state action. See Shelley, Burton, Lugar for the analysis. When government enforcement is present, okay, constitutional protections apply. So sources and where to read, okay? You have to read, people, because nobody is going to be in that courtroom with you unless you hired a private attorney or an attorney. But you got to, like I said, you got to put them in private. You got to give them some instructions on what you want him or her to do, period. Bottom line. I cannot stress that enough. I've seen too many people get burned by these people, and they don't care about you. It's all about profit. Okay, so let's go where you can read these sources, right? Okay, I would not have you guess at the authority, right? Okay, I'm kind of out of breath here. Sorry. Okay, you want to read the primary opinions, not summaries alone. Here are the core sources I use, and you need to read them. Primary Supreme Court opinions. Read the opinions of Crandall versus State of Nevada, 73 U.S. 35, 1867. Kent versus Dooley's, 357 U.S. 116, 1958. Shapiro versus Thompson, 394 U.S. 618, 1969. And you can see the law-annotated summaries on the Cornell or Justia. Saenz versus Roe, 526 U.S. 489, 1999. See Cornell, Justia for full text and commentary. Murdock versus Pennsylvania, which is my favorite, 319 U.S. 105, 1943. Bell versus Burson, 402 U.S. 535, 1971. State action cases. Shelley versus Kraemer, 334 U.S. 1, 1948. Burton versus Wilmington Parking Authority, 365 U.S. 715, 1961. Lugar versus Edmondson Oil Company, 457 U.S. 922, 1982. Jackson versus Metropolitan Edison Company, 419 U.S. 345, 1974. Blum versus Yaretsky, 457 U.S. 991, 1982. And you also want to look at the 10th and the 9th Amendments and the annotated doctrines. See Law.Cornell, Legal Information Institute, pages for Amendment, I think that's Amendment 9 and 10. Okay, where to follow current developments, SCOTUS blog, analysis and relist, Supreme Court official docket, supremecourt.gov for petitions and filings, search right to travel, or relevant state statutes. You want to go to Reuters, Washington Post, for major federal constitutional rulers that implicate travel. Okay, so one of the examples I used was April the 1st of 2025, Alabama, federal decisions on aiding out-of-state abortion travel. Law.Cornell, Legal Information Institute, for annotated constitutional topics and primary text. Okay. All right, so now we are at the end of this segment of the episode. I just found this. Now we're going to get into the letter that was written to the governor at the time of Raleigh, North Carolina. Okay. It was dated November the 23rd, 2015. The governor at that time was Pat McCrory. All right. And it says, read. violations of U.S. Supreme Court rulings regarding the right to travel. And then it says subject, education of law enforcement in North Carolina judiciary. It says, Dear Governor McCrory, so we are sending this correspondence to make you aware of the unconstitutional acts committed by your law enforcement agencies and state courts against the people of North Carolina. These acts may or may not have been committed knowingly or unintentionally, which we know is always knowingly and intentionally. But let me get back to this letter. But we are writing to your office to ensure that these violations are brought to your attention so that they can be addressed and corrected. As you may or may not know, which the governors, they know, there are people in your state whose status is ostensibly different than the average U.S. citizen and are considered foreign nationals or American nationals with certain safeguards and protection under the law. Our primary concern is that their travel rights in your state are not infringed, right? In order to educate law enforcement regarding foreign nationals or American nationals in your state, you can call the Department of State here in Washington, D.C. to get clarity, or you can go to the Department of State's website. Our website, they got the website in PDF, download the PDF manual and all this stuff, right? Department of State also offers training for law enforcement officers free of charge to raise awareness and compliance. It says log on to travel.state. And that's what a lot of them need. They really need to be trained on the difference between a U.S. citizen and a state citizen or American state national. Okay, all right, which I am a state citizen, American state national. I don't claim U.S. citizen. I never was a U.S. citizen. I was not born in the District of Columbia or their federal territories. And that's a different episode that's coming in the coming future about the difference between the U.S. citizen and the state citizen. Okay, so let's get back to the letters. We have enclosed one of our affidavit forms for the exemption of registration and licensing for foreign nationals that foreign nationals have to file in your state to lawfully claim the exemption. This affidavit also can be used by U.S. citizens who are not driving or operating motor vehicle for profit or hire. This is what I've been talking about in this podcast, people. If you're not for hire, okay, meaning if you're not Uber driver, truck driver, if you got to drive for a corporation or company, you don't need a driver's license, period. The Constitution has only given them the power or the jurisdiction of commerce and civil litigation. That's it, not criminal laws. We're going to get into another episode in the future about criminal laws, period 2 as well. So it says, please forward this information to all of your law enforcement agencies in your state to prevent any unnecessary lawsuits from being filed against these agencies for not following the law and violating the rights of the people to freely travel without interference unless they are a threat to public safety. If you have any questions regarding this matter, please feel free to respond in writing by mail or fax any questions or concerns you may have, and we will be happy to answer and address them. Thank you in advance for your cooperation and consideration in this matter. Best regards. Okay, I guess this at the time is Norvey Eisenberg Foreign Nationals Division. Okay, and is at the bottom, it's got Department of Justice Attorney General Loretta Lynch and Department of State Secretary John Kerry. This was a long time ago. So anytime these officers act like there's no such thing as a right to travel and you have to need a license, they really fooled themselves, or they have been misled and confused and been brainwashed by the truly evil people that's at the top, that's in power, to brainwash them to thinking that is so. But I'm quite sure they know. Okay? Rights are not negotiable. Licenses are conditional. When any government actor tries to convert your rights into paid permissions, show the law back to them. Read the cases I cited. Preserve your facts. File the record. Get counsel. Invite public attention. I'm Malik Liberty. This is Unchained Frequency, where authority meets the Constitution And Liberty answers back, no fluff, no fear,